Okay. Where's EJ? Alright. Hello. Parang haba-haba to. Alright. Good afternoon. By a unanimous vote of all those participating, the Supreme Court en banc denied with finality the motion for reconsideration filed by the House of Representatives, which sought to reverse the Court's July 25, 2025 decision that declared the articles of impeachment against Vice President Sara Z. Duterte unconstitutional. It affirmed that the fourth impeachment complaint transmitted to the Senate on February 5, 2025 was already barred by Article 11, Section 3, Subsection 5 of the Constitution. Associate Justice Alfredo Benjamin Caguioa took no part. Associate Justice Maria Filomena Singh was on leave. The Court clarified the following points. First, the first three impeachment complaints filed in accordance with the first mode of initiating an impeachment, that is, Article 11, Section 3, Subsection 2, were not placed in the order of business within the required 10 session days. Session days as used in Article 11, Section 3, Subsection 2, or for purposes of the first mode of initiating an impeachment complaint, does not mean legislative session days. A session day for purposes of Article 11 in the Constitution was given its plain and ordinary sense, which the Court interprets to mean a calendar day in which the House of Representatives holds a plenary session. Second, the Court reiterated Gutierrez versus House of Representatives. However, it further elaborated that an impeachment complaint filed in accordance with the first mode of impeachment, which is Article 11, Section 3, Subsection 2, is deemed initiated for purposes of the one-year bar in Article 11, Section 3, Subsection 5 when a properly verified and endorsed impeachment complaint is referred to the Committee on Justice. B. A properly verified and endorsed impeachment complaint is not placed in the order of business of the House within 10 session days or referred to the Committee on Justice after it has been put in the order of business within 3 session days as required by Article 11, Section 3, Subsection 2 of the Constitution. Or C. No articles of impeachment are transmitted to the Senate before the House adjourns sine die. This means that the initiation of an impeachment complaint must occur during the term of Congress. Third, the Court affirmed the power of the House of Representatives to promulgate its own rules on impeachment. However, it clarified that Section 2 of the House Rules, as it is currently worded, requires the referral to the Committee on Justice even when it is filed through the second mode. The second mode is provided in Article 11, Section 3, Subsection 4 of the Constitution, where the endorsement of at least one-third of the members of the House of Representatives would be sufficient to transmit the articles of impeachment. In view of the current wording of Section 2 of the Rules on Impeachment, as drafted and promulgated by the House in its 19th and 20th Congress, the House may, optionally, upon its own prerogative, refer an impeachment complaint already endorsed by at least one-third of all its members to the Committee on Justice, but only for the following purposes. Number 1, to ensure that the endorsement of the members of the House is verified. Number 2, to confirm that the evidence supporting the grounds in the complaint exists and that every member of the House has been given a copy of the complaint, as well as the evidences supporting it. And 3, to respect the committee's prerogative to consolidate different formulations of the complaint, if any, so that only one complaint is endorsed to the plenary for transmittal to the Senate. The Court observed that there is a fundamental difference between the first and second modes of initiating impeachment complaints. Thus, it said, and I quote, Article 11, Section 3, subsections 2 and 3 cover the first mode of initiating an impeachment complaint. Article 11, Section 3, subsection 4 covers the second mode of initiating an impeachment complaint. In the first mode, impeachment is initiated through the regular and deliberative process in the House of Representatives. A verified complaint may be filed either by a member of the House or by a private citizen with the endorsement of a member. Upon filing, the complaint is referred to the House Committee on Justice, which evaluates its sufficiency in form and substance and conducts the appropriate hearings. Only after favorable committee action does the impeachment process proceed further. This mode therefore emphasizes institutional screening and committee review. By contrast, subsection 4 introduces an alternative and a more direct mechanism for initiating impeachment. Under this provision, a verified complaint or resolution of impeachment signed by at least 1/3 of all the members of the House of Representatives immediately initiates impeachment proceedings. These provisions reflect a deliberate constitutional design. Subsections 2 and 3 provide a structured and committee-directed approach, while subsection 4 allows a streamlined initiation when a sufficient level of consensus already exists. Fourth, the court affirmed that due process of law applies to the impeachment process. It stated, and I quote, "The phrase right to life, liberty, or property should not be read with undue literalism. It must be accorded reasonable flexibility to achieve its intent of protecting inherent and inalienable rights that could not have been exhaustively articulated at the time of its framing. The Due Process Clause embodies a fundamental constitutional commitment to reasonableness, fairness, and non-arbitrariness. It envisions that we cannot have a true democratic and republican or representative state that is arbitrary and unfair. However, due process as it applies to the impeachment process is sui generis or in a class of its own. Full-blown trial happens at the Senate. At least for the second mode of initiating an impeachment complaint, it only requires 1. The grounds invoked in the complaint or resolution are those contained in Article 11, Section 2 of the Constitution. Number 2. The procedure is governed by the rules on impeachment promulgated by the House prior to any filing of any impeachment complaint. 3. As already provided by the current House rules on impeachment, all endorsing members should have been given a copy of the complaint and all its supporting evidence. The court also noted that the transmittal of the articles of impeachment should be done in a plenary session of the House, providing all the members of the House with full copies of the complaint and its accompanying evidence mentioned in Rule 4, Section 14 of the House Rules on Impeachment. Transmittal to the Senate, however, requires only a vote of 1/3 of its members for the first mode of initiating a complaint, or proof of the endorsement of a complaint by 1/3 of its members for the second mode. Fifth, the operative fact doctrine cannot be invoked by the party directly responsible in the commission of an unconstitutional act. Thus, it does not apply in this case. Finally, the court noted all the motions for intervention and pleadings filed by individuals who were not parties to the case. This resolution is immediately executory upon digital service on all parties in accordance with AM number 25-05-16-SC or the guidelines on the transition to electronic filing in the Supreme Court. No further pleadings will be allowed. The resolution and the motion for reconsideration and the separate opinions are being uploaded and served on the parties. Thank you very much. Any questions? Or still downloading? I can imagine. Digest stuff. We can start? Yes. Gyro.
Hi, Attorney. Gyro Bollero from Rappler. Just a clarification, Attorney. Even on the resolution of the MR, Justice Kagiwa did not, take part of
Yes.
that, and Justice Singh was still on leave.
Yes.
Okay. Another question. Can you expound on the explanation of the court on why the doctrine of the operative fact was not considered in the
Yes.
in the resolution? Thank you.
So the court said that the doctrine of operative fact does not apply when it is used to try to justify an unconstitutional act. And since the impeachment complaint, the fourth one was already barred, right, by the 1-year bar rule, and then that the non-action on the 3 complaints because it was not, they were not put in the order of business within the 10 session days, so that was unconstitutional. So it cannot be used to justify this action.
Good afternoon. Adrian Ayaling, ABS-CBN. So, ibig sabihin nito, attorney, wala nang pwedeng gawin ang House of Representatives kung final na. Meron pa silang pwedeng gawin, i-file, halimbawa, ang HOR.
What do you mean?
Kung gusto nilang for reconsideration uli, or may appeal pa ba uli, or talagang final na?
It was denied with finality, and the court said that no further pleadings will be entertained.
Although hypothetical, kung hindi pa ito na-decide before February 6, parang yung MR nila is still active, parang they can't proceed with any a filing of another impeachment complaint, theoretically speaking.
Well, it's not the case now, but if you would remember, the original decision said that no other impeachment case could be filed until after the 1-year bar rule.
Thank you.
Any others?
Attorney, just another question.
Sure.
There are ongoing impeachment, complaints before the House of Representatives, and basically they're adopting the 2025 ruling of the Supreme Court on the procedure for impeachment. Now, with this clarification on, for example, the Gutierrez precedent, gagamitin na po ba itong ruling ng Supreme Court on the MR, yung clarifications na to, on the current impeachment proceedings before the House of Representatives?
Well, this resolution of the Supreme Court is its latest, and it clarified a number of things when it comes to the 2 modes of impeachment, the due process requirements required for each mode, as well as when each mode is deemed initiated for purposes of the 1-year bar rule. So yes, it will be this one that should be followed.
Hi, ma'am. Tej Tupas po from Inquired.
Hi, Tej.
Ma'am, clarify ko lang. So, wala na yung Francisco ruling. Ito na yung susundin niya.
Actually, no. Francisco and Gutierrez are still good decisions, and it also said that yes, the court followed Gutierrez, but it expounded on it. Kasi kay Gutierrez, what happened there was a referral to the Committee on Justice. But then in this case, what happens when it is not referred? What happens when it is not put in the order of business within the 10 days required by the Constitution, or it's not referred to the Committee on Justice within the 3 days thereafter as required by the Constitution?
So, nilagyan lang ng options yung from Francisco ruling.
More like it clarified the ways in which the first mode of impeachment is deemed initiated.
Ano, isa pang question?
Yes.
Ano po yung date ng promulgation?
The promulgation was nung Wednesday. Kahapon. January 28.
Ma'am.
Yes. Any other questions?
Hi, Mitch Velasco po from Kutang Bato News. We wanted to ask, what was the vision and intention of the ponente, and did he consider the impact of his decision on the Constitution and the future of the Filipino people?
Okay, so I am not privy to the deliberations of the court, nor am I privy to the mindset of the ponente, but what I can say is this decision of the court made sure that the constitutional rights are still protected in impeachment proceedings, and it actually expedited the proceedings with its interpretation of session days. Thank you. Any other? Yes. Hello.
Dante po. Clarification
Dante.
na naman. So wala pong nangyaring changes, ma'am, sa voting dun sa unang ruling doon sa July 25. The same din po yung ngayon.
Yes. Unanimous for those who were present. Yes.
Good afternoon po. Ako po si
Hi.
Arnes from One News. Confirm ko lang po, so yung MR decision po, we can still proceed po with the February 6 na one-year bar rule since may mga impeachment complaints na po na inihain sa House recently? Or ngayon pa lang ulit mag-i-start since may decision po yung sa MR na House?
Again, it will be after the one-year bar rule from the transmission of the articles of impeachment last Feb 5.
Sige po. Maybe off topic on that, but recently po, there are, Zaldico's camp filed a motion for DRO, Ombudsman, and ICI. May we know or touch on the process on it po? And since it was filed in overseas naman, notarized then from Sweden, ano po yung process ng SC on that petition of Zaldico po?
Well, right now, it will be immediately included into the agenda, and we will give further updates as soon as they are available. Thank you. Yeah.
Saldic. Is it covered by the recent rules issued by the Supreme Court barring fugitives from availing judicial relief?
We will have to wait and see what the court, or how the court acts on his petition. Thank you. Yes.
Mama, another issue po. Ano lang siya. Marami kasing nagtatanong sa social media. May yung amendment ma'am ng Rule 138 on refresher. Tama ba ma'am na na wala na yung one-time use of the review course? Meron na ngayon 3-time use, 3-year validity, including review centers.
I'll have to check on that and I'll get back to you as soon as possible.
Thank you, ma'am.
Thank you. Alright. Isa pa! Isa pa!
Ma'am, other issue lang po, ma'am. Ma'am, kahapon, the COMELEC was declared the postponement po ng BARM elections. But there was an order by the Supreme Court na parang dapat magpasa ng batas ang Parliament on or before October 30. Ano po yung pananagutan ngayon ng COMELEC kung hindi nila masusunod yung Kasi sabi ng Supreme Court, there would be an election on or before March 30. But kahapon po nag-declare silang di na po nila kaya. What will happen po? Thank you.
Well, we'll just have to wait and see what the court says about that, especially if any of the parties file a pleading or a manifestation in the case. Okay. Thank you, guys. Thank you very much.
Welcome back to my channel, guys.
Welcome, Arby Vlog!